Hey, Brian Parker here from collectionstoppermembership.com. We do these free YouTube videos also, but if you want the accompanying documents and all the research and all the templates that go along with these videos, you can go to collectionstoppermembership.com. Two new things, just wrote and finished an ebook, How to Write a Killer Answer to a Collection Lawsuit. That's dropped, and also a new one, Mastering the Intricacies of ID Theft and how to get credit disputes off your, how to get credit stuff off your credit with disputes and validation letters, all in an ebook. It's very tight, and it has my own personal experience that I went through. And I say that to you not because I'm an egotistical guy, because I'm very much not, but you can see that I know what my clients that go through ID theft go through in the ebook. And hopefully that makes it more relatable. And that's important to me. And as I always tell clients, there's nothing you've been through that I haven't experienced myself. And I think that's important for attorneys to have empathy, especially when it's true. Anyway, this is our Creditor Series week. I think for the week I'm going to be doing creditor defense against creditor lawsuits. They're toughies, but as you know, if you're a faithful disciple of my channel and my membership site, it's all about the assignments, but more importantly, the securitization, which every debt has gone through. You saw my videos, and I'll say this as a frame of reference last week with the 4 quadrants, meaning there's 4 kinds of debt. There's creditor debt, there's creditor/servicing debt, debt buyers, and then companies that just are totally securitization mode that they then sell to debt buyers, and the debt buyers are kind of screwed. We're not sympathizing what the debt buyer is going through, but it helps you. This is a BOA lawsuit. Let me put page 1 and page 2 up. Shazam. I'm going to talk behind it for a bit. There's really something cool that you should notice or not notice. I'll give you 15 minutes. No, I'm kidding. But review, if you go to my membership site or up here, here's the weirdest thing. And I've noticed it now in all my other creditor cases. I never noticed it before. The word debt is not referenced in the collection lawsuit when it's Citibank or it's BOA or Wells Fargo or any other JP Morgan. They're not talking about the debt. They talk in terms of account. Why do they do that? That is directly because what BOA is collecting upon is an account versus a debt. And if you were to go and look, just Google the definitions, they're not the same. Why differentiate? Because they're not collecting a debt. That thing was shifted and sold and transferred, as we've talked about before. It's a securitized trust. Minimally, it's whatever they're supposed to receive in receipts from you, as far as payments, or the whole debt has been sold or transferred. It can only come back if it is assigned back to the company that is now suing you, and is suing you not for a debt, but an account. That's why a lot of these cases are called account-stated debts. They don't have the contract they're claiming to have all along. If BOA is suing you for breach of contract, wouldn't it have the contract? Rarely is that attached to the lawsuit. So look at the affidavit that accompanies the collection lawsuit against you. Let me put up this one that I'm using today, 2 pages. Shazam. And in this case, the affiant, that's the person that signed the affidavit, is saying, hey, this is all true, you can trust me. Well, this affidavit was signed well before, I believe 59 days before the lawsuit was filed. Yet they are referring, and by the way, the word debt isn't in the affidavit either. They are referring to my client in this case as the defendant and themselves as the plaintiff. Well, that is wholly false. So when she signs under oath that you are a defendant and BOA is a plaintiff. It's not technical because they have a little caption there like it's a real lawsuit or something. It isn't. So that is a falsehood, and they've sworn under oath something that is not true. Nothing they say can come in at that point. These are all nuances that are very important. Thirdly, in a creditor lawsuit, you got to have your custodian of records affidavit. You're the custodian of records of your case, but it's got to be the counter affidavit. I've done at least 5 or 6 videos. I always do this because I'm pointing to, hopefully my editor puts the stuff in, the killer affidavit, the account statement affidavit, and all the other videos that are on collectionstoppermembership.com. That is everything. And let me put, I think there's 2 or 3 pages of the counter affidavit up Shazam. You can see the emphasis that I have on the fact that this debt was securitized. In that affidavit, and you should do this too, go grab on Google the actual paperwork. It's simple. Just go Bank of America, securitization, 10K financial reports of the year that your debt was created. And you'll see all the information you need on securitization. I attach it to the counter affidavit. That counter affidavit is full of everything you need to take on the bad guys. And the counter affidavit, as I've preached before, follows you all the way through to trial if you go to trial. It should follow you all the way to settlement. And in this case, I'm settling it early and easy just on that securitization aspect alone. Thirdly, I send discovery saying, hey, how about show me all the securitization paperwork? Show me payments are made. Show me this, show me that. And I'll just put you up a quick interrogatory selection, Shazam. And that you can see I'm asking about the securitization of it. You go to SEC, and it's regarding your need to go where all this stuff is stored. I wouldn't do that now that I'm saying that and I've got it in my interrogatory. Just Google it and then shape the requests that you want to make in your interrogatory. But attached to my membership site with this video will be discovery for BOA and also a counter affidavit, an answer, lots of stuff attached to my membership videos on collectionstoppermembership.com. So you got to remember this whole thing is based upon securitization. What is the real genesis of securitization as it relates to you defending yourself against a creditor lawsuit, which in the past has been real hard to do? It's about the assignments. Very quickly, a debt is agreed to with you and the creditor, be it BOA or Amex or any of those. When that is taking place, they ship the debt off to a securitized trust or an ABS, asset-based securitization, and it is remote in that it can't be owned by the creditor, so that then they can go borrow more money based upon a very healthy bottom line balance, because your debt, which could bring stuff down as far as it's just like buying a house. The creditors have to have a good debt to income ratio. So they get rid of your debt and give it to a secure trust. If and when you default, then that trust assigns it back and then they can sue you. Problem is, they don't. They can't. They won't. And either way, the evidence of that must be attached to the lawsuit suing you. So you've got a card with Citibank, they sue you for default. Got to see ownership proof. Just go Google securitization in Citibank or BOA or Amex. It's right there for you. Attach it to your counter affidavit and you have the best defense possible to put yourself in a settlement mode. Be tough, be strong, beat these guys, because they're just as confused as you may be listening to me right now when you present them securitization. However, listen to me, follow my stuff, go to collectionstoppermembership.com, which has tons of videos and paperwork and templates just on securitization alone, and be the smart person in that litigation. you will win, because the debt collector attorney's got 150 other cases. He doesn't want to deal with this nonsense. He certainly doesn't have to learn stuff. Learn stuff, beat him, and win your case. Good job, Brian Parker.